Good morning, good afternoon. It's really nice that everyone's able to join us on this webinar. I'm David Merchant. I'm the president of TechLaw for this auspicious year and last auspicious year. I'm a partner at Meitar, which is Israel's largest law firm. I specialize in, I head the commercial technology and privacy department. And today we're going to have a session on, so just tell you a little word about what TechLaw is. TechLaw is an association of leading tech law firms in over 20 countries on 6 continents, if we consider Australia a continent. And the idea is that it allows us to stay up to date on new developments in laws that are relevant, tech and privacy laws and others that are relevant to us, and also to help our clients, and therefore to be able to access quickly and easily advice from our member firms around the world. And this is an example of what we do a few times a year, of holding these sorts of webinars. We used to do it in person, and hopefully again we will in the future. So I want to jump right in to we'll have 2 sessions today, both relating to privacy. The first one is dealing with how do we transfer data of EU individuals outside the EU in light of the Schrems II decision. The second panel will deal with data localization, and we'll talk particularly about the situation in China, Russia, and Australia, and we'll have panelists from those countries. And so I just want to introduce the panelists in the first session. We have Olivia Maluli, and she's a partner at Arthur Cox in Dublin, where she does a lot of IP, information technology, and data protection advice to clients in the EU and beyond. And we have Aurelio Lonigo. He's a partner at Tenuto. He sits in Padova, Italy, and he has for more than 20 years has been advising clients on data protection and corporate compliance. We're glad to have him. And finally, we have Jim Koenig in New York for Fenwick, and he has long experience in data protection, and I think he's advised something like 35 of the 100 the Fortune 100 companies on data protection, and he's kept most of them out of jail. So anyway, I want to jump right in, and so what's the first session going to be on? Which is, it's going to be about the issue of how do we transfer data of EU individuals that are collected and transferred out of the EU. So I wanted to start by asking Olivia about the structure of the GDPR and in transfers of data of EU individuals outside the EU, and a little bit of how the Privacy Shield played into that.
Sure, thanks, David. So in short, the journey from the old data protection directive into the GDPR, from a procedural perspective, didn't see a huge amount of practical change on the ground for clients, because we still had, for example, there was Privacy Shield at the very start, that we had standard contractual clauses as being the mechanisms in which data could be transferred out of the EU. There are a small number of countries that are recognised as adequate by the European Commission for transfers, but it's a short list. Israel is on it, Japan is on it, New Zealand is on it. There's not very many others. The UK is in a queue to get approved. You know, we'll know kind of shortly enough whether they will get that adequacy decision or not. But unless you're in one of those countries, you're looking at needing to rely on a transfer mechanism to validly transfer any data that you have outside of from the EU, for example, to your parent companies, affiliates, service providers, whatever. The history of this has been quite checkered, and it goes back to a challenge by Max Schrems, the Austrian privacy campaigner, relating to transfers on the basis of Privacy Shield. Following a Court of Justice of the EU decision a few years back, they not quite invalidated Privacy Shield, but they said this didn't provide an appropriate level of protection for data outside of the EU because of what they perceived as deficiencies on the US side. And Jim will be able to speak in more detail about that. And that's really where it only left us with standard contractual clauses, or model clauses as they're commonly referred to, being controller to processor or controller to controller. They were also challenged by Max Schrems, which came before the European Court in the last few years. It issued its judgment last July. Didn't say that they weren't adequate, but they did say that the onus is now on controllers when they're sending data outside the EU to ensure that it has that equivalent level of protection from when it leaves the EU to whatever destination it's going to. And of particular interest in that was the rights of the US government to access data. So Aurelio, if you have anything to add to that in terms of the journey, you might want to chip in.
Yeah, I think it would be good, Aurelio, if you could talk a little more of the specifics of the holding. It was last July that the European Court decided to invalidate Privacy Shield. So maybe, Aurelio, you can talk about some of the basis of that and where does this leave us? Yes.
Well, first of all, like the name of the ruling comes from Maximilian Schrems, who is an Austrian citizen who basically with his network NEOB started like a kind of like crusade against like the big players of social networks and internet regarding the respect of data protection legislation while transferring personal data outside the European Union. As we already said, like he achieved like different goals. The first goal was like far before the GDPR, when there was like the safe harbor privacy principles, who was actually ruling the transfer of personal data from Europe to US, and that agreement was declared not valid because it was not in compliance with the basic principles of the European Union, and that was like a judgment of the Court of Justice of the European Union. And the same situation we find it with the Privacy Shield, as Olivia said, and basically because the court found that the principles of the Privacy Shield could not be enforced against the US legislation that deals with surveillance or for the public interest or administration of justice. And such limitations were actually that are actually in the US legislation can be found also in the European one, but the problem is that the US legislation doesn't actually limit such powers of public authorities in order to process and access data, and therefore the interference of on the data protection rights and of the data subjects, European data subjects whose data were transferred, cannot be ensured once their data is abroad. So basically, the court says that the lack of limitations of these aspects of the US legislation and the absence of remedies for the data subjects to apply to in order to have their data protected and guaranteed actually determined that the US legislation could not comply, giving like an adequate equivalent level of protection of the data. So as Olivia already said, and maybe they will Jim will say a little bit more later, the Privacy Shield was considered invalid. And regarding the other like tools that are provided for by the GDPR in order to allow the transfer of personal data, also the standard contractual clauses were actually compromised, let's say that, because clearly the court said that in order to rely on such clauses, it will be necessary to assess the legislation of the third country where your data are transferred, in order to see if the legislation of such country allows actually the importer to respect what is provided for by the standard contractual clauses. And of course,
so maybe I'll just stop you there,
yeah,
just to emphasize. So now the EU, the court wasn't able to analyze exactly what was permissible, and now each of us is supposed to, and our clients are supposed to analyze what the situation is in the US in particular, but any other country also, what's the situation of protecting the personal data. So we're left with this really difficult situation as a practical matter. So and this is really the key question here, which is, what are we advising our clients in light of this somewhat, let's call it, and I won't call it crazy, I just might call it broad-ranging decision. So Jim, you go first, and I want to sort of go around then Olivia and Aurelio afterwards. We're left with this. What practically are you advising your clients when they want to transfer data of EU individuals outside the EU?
At this point, I would agree with you, a little bit crazy, in that on the US side, or global companies that have large US operations or headquarters, the flight to standard contractual clauses is most frequent, and we support that as the least cost, less legally vulnerable transfer mechanism that's there. Don't get me wrong, Americans loved their safe harbor and privacy shield, right? It allowed free transfers of all data that was specified without identifying the uses. It took jurisdiction for transfers away from the different European countries and only put it at the Federal Trade Commission. And so when Privacy Shield, when Safe Harbor went down, then everyone went to standard contractual clauses, then back to Privacy Shield. That was invalidated. Now standard contractual clauses. People have looked at binding corporate rules, but it's not a silver bullet. It's expensive to build, expensive to maintain. And so clients are sticking and migrating towards standard contractual clauses. And at first, maybe Americans didn't take it serious enough, as this started as a project for Max Schrems when he was at Berkeley to challenge Facebook as part of a class project. Who knew that we would be sitting here years later and defining global privacy by his class at Berkeley? So yeah, a little bit crazy, and companies are a little bit fatigued by all the changes. So they're migrating now to the safest, most common thing that they know they can control: contracts.
Yeah, so anyone who teaches in law school, I might suggest from now on, do not in the future ask your students to do something practical and have an impact on things, because this is what we see actually happens in these cases. Olivia, what are you advising your clients to do?
So when the draft recommendations were issued by the European Data Protection Board last November, that certainly, gave some kind of a roadmap on which kind of some practical steps that you could take. The question is, a lot of them are not very practical in terms of the onus that's put on controllers. The second point to make is they are draft. So, we don't really have any kind of concrete guidance to go on. In line with that, the standard contractual clauses are being updated, because the current ones that are still valid were drafted under the Data Protection Directive. So, we're expecting those to come to final form later in the summer, all going well. At the moment, really all you can tell clients is there is no one size fits all, which is what the EDPB recognizes, and to take a risk-based approach, which the GDPR always kind of recognizes. The word risk is mentioned several times through the GDPR in terms of how you approach a privacy program. So things like data minimization and retention periods, and all of those key principles become even more enhanced when you're sending data outside the EU. Don't send what you don't need to send. Don't have your service providers or whoever the recipient is hold on to it for longer than it's held on to. Look at your security measures. So can you use encryption? Can you use pseudonymization? Is there anything from a practical perspective that you may, you know, which is one of the principles in the GDPR, but you really need to be looking hard at them when the data is leaving the EU to provide all of those added protections. I've seen some clients ask their data recipients outside the EU, and particularly in the States, because, you know, let's be honest, that's where all the focus has been in the last few years. Sorry, Jim. In terms of what they can do from what assurances they can give in terms of, you know, are they subject to government access rights and so forth, with mixed success. Like some of the recipients, they don't give, you know, helpful answers, or they don't give clear answers. So it really comes down to, is this actually a risk for the data? Are you just sending people's names and email addresses? Or are you sending kind of more sensitive data that might, you know, give an insight into people's health or behaviors or interests and all of that, that would enable kind of a person to be profiled and kind of go from there. So for now, there's not really very much you can do, only maybe take a toolbox of some of those measures and see how you go.
Okay, so really, what are you doing? How are you advising clients? And maybe in particular, when you're supposed to, even under the standard contractual clauses, one of the holdings in Schrems 2, you're supposed to, you know, confirm that the recipient country provides adequate protection. So what are you doing in that regard? You know, how are you dealing with that? And I guess the other question I would ask is, are you dealing with the US differently than other countries?
Well, right. Well, the first thing we actually suggest is to avoid any transfer, of course, but it's clearly like almost kind of impossible in this like hyper-connected society we actually live with. So the very first steps is actually following the recommendations that Olivia pointed out. The first step is actually to have a clear map of where actually your data go, because most of the times, like, clients do not have any clue where actually their data go, because they just have the very first view, considering their first supplier that provides them with IT services, but then they don't go any farther. They don't know if this supplier actually deals and has agreements with further sub-processors. And so the very first step is to have a clear view of where actually your data go, and also considering the different steps of the transfer from one processor to another processor and so on. So that's clearly the very first thing we suggest to do, and it's actually the very first step that the recommendations of the European board actually prescribe. And after that, if the transfer needs to be provided for, all the steps that Olivia pointed out are actually what we also suggest. So first of all, following and being able to document your assessment for the transfer, because if any issue arises, according to the principle of accountability, you must be able to provide to the supervisory authority what you actually did in order to analyze the situation and to analyze the risks of the transfer, and what measures you actually decided to apply in order to strengthen the measures that the standard contractual clause, for example, guarantee.
Okay, so I want to maybe stop you there, Jim. What documentation are you telling your clients that they should keep to prove that they did this, that they did this analysis that Aurelio and Olivia had suggested?
Well, it's not how much what they keep, that U.S. companies are being pummeled with requests from foreign and European partners and companies to fill out transfer assessment questionnaires, to fill out supplementary measure questionnaires, which the first thing that they ask every single time of every company is the exposure to FISA, the Foreign Intelligence Surveillance Act.
So
and
you
the
want to
executive,
Jim, maybe give a 1 minute summary of what is FISA and why is that relevant?
Sure. And Executive Order 12333. So collectively, what those are broad surveillance authority of the U.S. government that allows it to request of companies information in their pursuit of terrorists, threat actors, and others. But typically, these powers and the way that they're focused are on telecom operators, social networks, and email hosting service providers, the Microsoft, Gmails, and others of the world. But because it's email hosting service, every company that provides its own employees email can fall into the scope. And so most companies in the US never receive a FISA request, aren't really subject to it, aren't open to it, but it is caused an avalanche of the questionnaires from Europe that are not focused on those types of requests. And so that's where we start the equation. But what do we tell our clients to prepare? So typically we tell our clients to prepare almost a frequently asked questions to either provide or to answer these questions that come up, that we are subject to FISA like every other company that operates in the United States, but we haven't received, we don't anticipate getting a request, and that if we do, we're willing to notify you and let you try and fight it. There are a lot of European companies and others around the world now that are trying to demand that the U.S. Recipient actually fight those requests. So there's a lot of fighting, filling out these questionnaires for companies like pharmaceutical companies and others that would just never get these requests. So there's a lot of expense, burden, and cycles just because people really aren't clear of what the laws are, what they really need. But as a practical matter, besides the documentation, a lot of companies, if they haven't now, are putting in pseudonymization, end-to-end encryption, those technical measures, if they didn't have it already, that would answer the question if we have these supplemental safeguards that would answer the question and the risk based on the draft standard contractual clauses in the DDPP guidance from November 11th from last year. So that's the practical mixed in with this very large flurry of what I call generally unproductive activity, because what are you going to do when you hit, and my last point, David, what are you going to do when you hit these global data hosting companies? And all of a sudden, because they're subject to FISA and they're willing, that you're not going to host your data at, some of the largest, most secure data, companies in the U.S. We all know who they are, but since we represent a lot of them, I'm not naming them. But that's the hard part. And that's where people say it's politics, because now we're hosting data at less secure, less mature companies in country, in Europe, and in other countries around the world that are following the Europeans. So it's just a mix of things. I'm not political, but those are kind of where things are migrating.
So just to emphasize, there's really a distinction between, not legally, but practically, between those companies that are really likely to be subject to a FISA request, which are email providers, telecoms, data storage, and the rest of us. So I guess I'd like to ask Olivia, what are you doing when you actually get one of those? Okay, it's an I'll name a name. It's an AWS and being transferred to there. what are you doing in those cases? And I also want to ask, actually, any of you, which is, after you address this, which is, have you actually had a situation where you're not transferring the data? But Olivia, why don't you answer first the issue of what are you doing when you get one of these that are sort of bool in the target of the FISA requests?
Well, I suppose part of that is answered by your second point, is that clients are more exploratory now of data localization and to what extent their data can be stored within the EU and they can avail of an EU cloud. But otherwise, it does come back to what risk is associated with the data. Like as Jim says, are people tearing their hair out unnecessarily when actually the data in question is not high risk data, or the client in particular, is not somebody that would be subject to, in reality, these types of requests. So it really depends on what it is. I think clients sometimes take a lot of comfort from the ancillary security measures that these companies can offer. But it really goes back, if things are quite sensitive, they're tending to now look to data localization rather than relying on the bigger providers. But it's evolving all of the time. Just to kind of bring in one point, which is there's some, I think, publicity out there in terms of specifically what's happening in Ireland and the Irish DPC, because Facebook took a judicial review challenge to the DPC's draft decision to say that they should not send data outside of the EU to the US without having additional measures in place. That is not an actual ban. It was a procedural challenge. The Irish High Court, dismissed the challenge against the DPC's decision. So the draft decision is now has to go around the houses in terms of the European regulators. So it will be interesting in terms of how that plays out, because obviously the decision itself, I'm sure, will be challenged by Facebook in terms of those bans. So there's a lot of kind of clients waiting on the sidelines and kind of watching the wider environment in terms of what's happening and what they might actually be expected to do. But I haven't seen, large moves away from, the big tech companies like AWS.
Okay, so two things. First of all, I want to have one thanks very much. I want to have one announcement just briefly. If people have questions or answers, they should include it in the Q&A, and then not QAnon, and we'll be able to get that because we want to leave some time at the end of this session for any questions that people have. So I wanted to ask Aurelio. We've been talking up to now about using standard contractual clauses, and by the way, Olivia, in response, that one of the things that people are looking at, in a sense, is data localization. There's something that's really sad, I think. If there's anything we've learned about Corona and COVID over the last 15 months or so, is that these are really worldwide issues, and the idea of trying to be more nationalistic and try to solve things inside our own borders is really not the way to go. It's really a shame. But anyway, I see sort of, in a sense, that's the direction. But obviously, standard contractual clauses is one way that you can transfer mechanism. I'd like to ask Aurelio, I know consent is not a preferred method. What are the situations in which you're relying on consent of data subjects, if ever?
Well, clearly consent is one of the exceptions that are pointed out in the GDPR in order to allow you to transfer data from the European Union to a third country. Among other, there are several of these exceptions, but consent is one of those. But a consent is actually a little bit it's not as easy as it might seem. First of all, it has to be an exceptional situation, actually. So you cannot rely on the consent for a systematic transfer of personal data. And then also another important thing is that a consent has to be specific and actually free. So you must be able to deal in both situations where consent is actually given you or provided to you, or it's actually denied. So basically, on a, let's say, on a IT point of view, you should be able to deal with the data of your client in two different ways, provided that on one side he gave you the consent, on the other side he didn't give you the consent. Practically, we really limited, like using the consent. That we actually managed to use it only like in very limited situations, like for example, like for, let's say, for remote access from a third country to data of clients that are actually part, let's say, of a CRM program, and they need to, they are abroad and they need to get inquiries about their situation in the loyalty program. So in that case, it's a one-to-one situation, and actually the client provides you the consent because he needs to access to his data. And so that's one situation. Another situation might be for like medical research, for example, which is very detailed and specific and narrow the situation. Otherwise, using these options has to be very limited and occasional. It cannot be, let's say, the rule to be applied for the data transfer. And also, like going back to what was said about the localization, it's localization of data appears to be possible sometimes, because like the big players allow you to choose where the servers that actually provide you the services, the IT services are located. But then if you actually go through all the contractual aspects of the services, you actually see that some of collateral services actually do imply a transfer of or a remote access to the data from a third country. So even the option of localization is really hard to achieve and maintain from big players and for IT services. So it's actually really a tricky situation.
Actually, I thought maybe we would go to one of the questions. Anthony Ford raised this question about localization in the EU, that maybe it actually doesn't really help the situation because it doesn't actually shield that data from the US authorities, which is what the whole point is. And there's a statute in the States called the Cloud Act, which Anthony says might still compel a US company to access data in the EU. So I'm wondering, you know, do we really feel that as a data localization helps? And maybe Jim, I might ask you to, data localization in the EU helps. I assume it does because of the procedural issues that might be involved, but Jim, maybe why don't you address that?
No, the procedural issues to get at that data isn't good in all cases, and you know there was a big case around Microsoft that really set some of the boundaries around that. But to me, so yes, they try and strike the balance in that case, but I don't think data localization fully protects the data. As we talked a little bit before, a lot of this has to do with economics or a little bit about politics. I mean, originally the transborder data flow provisions of the Data Protection Directive were thought to be a non-tariff trade barrier to prevent the US internet companies from rushing so quickly into Europe, slowing them down because they had extra hoops for the transfers that they had to comply with and come up with compliance mechanisms. Now, data localization or even other attempts, right? The EU focusing on the US surveillance, the UK and the EU focusing on adequacy and the potential UK cooperation with the US in surveillance, US versus China and the CFIUS acts around TikTok and Tencent, China and India So there's a lot of legal actions that are happening, but underneath the surface, it's a lot about economics. It's a little bit about politics that that really gets there, that behind many of these laws. So yes, the Cloud Act doesn't fully shield those companies and from protection from U.S. surveillance, but I think when you look at the broader picture, there's a lot more going on there than just the legal aspects like the Cloud Act and the access to that data.
Okay, so far we've talked about how you actually comply with Schrems 2. How do you actually transfer the personal data outside the EU? We're talking about standard contractual clauses. We've been talking about data localization. We've talked about trying to take measures to do data minimization, and sending these questionnaires. I'd like to maybe just take a few minutes and say, what do you think about this? I mean, really, was the decision right? Sometimes we often don't do that. We say as lawyers, listen, hey, I wasn't the judge. I didn't do the law. We just have to comply with it. Don't shoot the messenger. But I'd like to shoot the messenger for the next 5 minutes or so. So I'd like to get a sense, what do you think about this? The EU called out the US and said, listen, you're worse than every other country, worse than us. Not sure it's true. In terms of US government accessing or having access to the data. So Jim, I'm going to let you go first as the American on this panel. What do you think about it? And then I'll have a responsible opposing viewpoint from the two Europeans on the panel.
This is an appropriate time to say the viewpoints that I'm about to express are those of my own and not those representing Fenwick or the United States government. I think it's really a lot of malarkey about the U.S. surveillance and that being the threat. I mean, the U.S. is part of a group called Five Eyes. It's an intelligence alliance comprising Australia, Canada, New Zealand, the U.K., and the U.S. That shares information. And I got a pretty good look at this because actually I was the person that was brought in to Booz Allen to clean up after Edward Snowden. And so I got a good look at the sharing, but the Five Eyes is what it is today. But there are parts in history where that alliance also had members or shared data with Norway, Denmark, West Germany, and others. So it is ridiculous to think that other countries don't surveil on their own people or people that are from outside their country. And so the focus on the U.S. in particular, I think partly because of the Snowden case brought a lot of attention to it. Great, we got caught, exposed, but I think as a practical matter, this is happening in many cases around the world, and it has a business drag. It is creating extra cycles, and the U.S. being picked on as part of it kind of feels unfair. That being said, in many times with our clients, we're the global architects of data flow, so we look beyond that. We come up with integrated solutions that works on global data flow, not just Europe to the US or China to the US or Russia or wherever it happens to be. And so we look past it, but just from my own personal moment, I think it just the way it's gone, the US focus and the drag and the amount of extra cycles on things that really aren't risk-based, how it's been played out. Maybe the guidance meant something better, but how it's being played out really is, at least to me, a little bit unfortunate for the drag on business and commerce.
Listen, Jim, come on. New Zealand in that group, come on. They're just requesting data requests from sheep. So come on, it's not really comparable. Olivia, what do you have to say to support the decision that it makes sense, it's fair, it's reasonable? Hey, as a European citizen, I really want to have that protection, and I'm all in favor of this.
So I understand the kind of concept behind it because, and I do agree with some of Jim's points, but as a structure, if you were to engage with in a contract with a third party, and they were then to say, well, you know what, I'm just going to get another party to do all the work here and I'm just going to outsource it to them, you're going to have a clause in your contract that says, yeah, but you're still responsible and they need to meet all of the same obligations as what you've agreed to give to me. So I understand the concept that European citizens do expect, you know, that kind of equivalence in terms of the protections that they've been told that they're entitled to expect. To take Jim's point, I agree that it's left controllers in this invidious position of trying to figure out how do we actually implement this. And I think it is sending some clients unnecessarily into a spin where they're trying to, you know, figure out, doing all this analysis when actually, you know, they're chasing shadows in terms of trying to get an answer, or it's not relevant to the type of data that they're talking about. So I think you just take again, I would just say, really what's being said here is look at your risk profile for your data and go from there, because there is no one size fits all. And I think some people have kind of gone too far, as Jim says, I mean, tying up his clients in knots in terms of some of the questions that they've been asked, when really we don't actually know what the actual expectation is from our regulators. So, you know, I would kind of be somewhere in the middle in relation to that.
By the way, Jim, I'm glad that you had called it malarkey and not maluli, but I wanted to maybe move to you, Aurelio, and to ask, where do we go from here? Like, what are you expecting? So now, you know, we've talked about what the practical solutions are. What do you expect? What do we expect next? What can we expect for, you know, in the next year on this? And is there anything that we should be planning for proactively?
Well, actually, what we actually can foresee is, first of all, like the recommendations we've been talking about now, as Olivia said, they're just a draft. So first of all, documentations and guidelines probably will become like more clear and strict and easy to apply to. Secondly, there will be like, of course, rulings from the courts, and let's see where these rulings will bring us. But I'm pretty sure there will be like new agreements that will allow to structure and the transfer of data with big players like the US or other countries, because it's literally impossible to think of a world without where all these services they are so connected that it's impossible to consider that data do not actually fly and are transferred. But as Olivia pointed out, I understand from like a data subject point of view. Here as European, I give my data to a controller who is subject to a legislation, the Gdpr, and he's supposed to guarantee and apply this legislation to my data. But if he gives the data to a third party that is absolutely not bound by these regulations, what's the point for me to give you my data? So it's actually also, from another perspective, is actually a little bit of a tricky situation, as I already said.
Yeah, although I might just point out that there's also the national security exception in the European Union. So it's not as if, you know, you say, listen, hey, you send it to the US and who knows what the hell will happen. No, also the same national security exception. So it's not as if, you know, my data is secure from these sorts of requests in the EU either. So, okay. So, okay. In our last 3 minutes, I'm gonna go around for one last time. First of all, Jim, one super quick question. Till now, we've been talking about transfers of personal data from the EU to the US. Let's just make sure that everyone's on board. Any restrictions transferring from the US outside the US?
Come to the US. We're open for business. There really is there's no restrictions on transfers out from the US. There are some government contracts and things like that where they only issue to suppliers that are local, and sometimes Medicare and Medicaid, some healthcare require on-site audits if things are offshore. But for the most part, data leaving the US is generally unencumbered. We focus more on the sale and sharing of information, like in the CCPA in Virginia, Nevada, but not the leaving of our shores.
Cool. Okay. So it's not just a Republican Democratic issue. All the United States is open for business. Biden will be really happy to know. Olivia, I was wondering if you could address a question that Craig Thorburn from Blake's in Canada asked, which is regarding the practical impact here, which is the enforcement actions. So what enforcement actions, if any, are we seeing from the transfers outside the European Union?
Thanks, Craig, for the question. Enforcement, in relation to Ireland, I've already mentioned kind of the DPC is investigating Facebook's transfers. On the other hand, there have been some decisions from your other European DPAs. I think there's only been a handful of them recently where they've been looking specifically at transfers, you know, either saying they're okay or not okay, you know, based on kind of mostly around kind of what measures they have in place and is there a consultation process for law enforcement requests. I haven't seen any private actions so far, certainly not in Ireland in relation to that, because there isn't a clear enough baseline within which you have to take an action. Really, you can't say, oh, you breached this particular guidance that's come from the European Data Protection Board because it's not final yet. So it's interesting in terms of where that goes, because the plaintiff bar in Ireland is starting to look at data protection more and more as a kind of an add-on to a wider dispute in terms of compensation claims. So I can only imagine it's coming.
I was hoping that we could end on an upbeat note. The last thing we want to know is, hey, there haven't been any class actions to date, but there will be. I mean, for litigators, maybe that is an upbeat note, but for the rest of us, we don't like that so much. So maybe I'm going to ask one last question. Aurelio, finish up in the last 30 seconds, something positive, something you say, wow, this is so great, and I'm looking forward to it. And with something positive.
Oh, gosh. Wow.
You're Italian, you're supposed to be upbeat, not like, you know.
Well,
maybe COVID will be ending soon, yeah?
Well, I mean, I'm pretty sure like all the situation about the transfer will soon become even more clear, because something will be done definitely from the Commission, between Commission, US, and other countries. So things will become more and more clear.
By the way, thanks very much. So on the upbeat note, maybe I'll always say that clients are always asking us, when is the draft guidance going to be finalized guidance? And to which we always respond, hey, next time you tell us that we're not responding quickly, just remember, if your lawyers were the European Data Protection Board, you'd have to wait a long time. Anyway, thank you very much. It was really great. I want to turn it over to Alessandro, who will be moderating the next panel. Olivia, Aurelio, Jim, thank you so much. It was great.
Thank you.
See you all tomorrow.
Thank you. Thanks.
Thank you, David. Wait for the other guys to join us. Okay, thank you, everybody. Thank you for having joined this second panel. My name is Alessandro Vasta. I'm a partner of Tenuto and Partners, and I've been asked to moderate this second panel, which addresses an issue which is very critical, especially for those who deal with digital services and international transactions. The issue is the problem of the interplay of different jurisdiction legislation in possessing of personal data. As you may know, almost 25 years ago, Europe enacted the so-called Mother Directive in 95/46, which was the first regulation on data protection. And from then on, many legislation, it was modified in many ways until 2018, when the GDPR came into force. And that initiative has paved the way for other jurisdictions to follow the same path. And today we are going to analyze how three major economies and jurisdictions like Australia, China, and Russia are facing the challenge posed by the so-called data-driven economy. And so let me introduce the speaker of today, which are colleagues from Australia, of course, China and Russia. Let me introduce first of all Maria Ostashenko. Maria is a partner at Hanno law firm. She has the commercial, intellectual property, data protection, and cybersecurity practice areas. She represents international clients in the matters involving data protection and cybersecurity in Russia. Hi, Maria. We have also Philip Catania. Philip is a senior partner at Corso, Chambers and Westcott. He practices in data privacy and commercial intellectual property law, and has represented many international organizations in managing data privacy matters, including data breaches being investigated by the Australian Privacy Commissioner. And then last but not least, Gil Zhang is a partner at Fang Partners, and he advised many clients on compliance projects relative to GDPR, Chinese law, and many other countries in Asia Pacific. He has extensive experience in data protection and cybersecurity issues, assisting clients responding to law enforcement and privacy litigation in China. Okay, I would like to ask you first of all to give us a quick overview of how your countries have regulated the data protection, and how do you face the issue posed by this legislation, which is of course very important for all the world at the moment. And so I will ask Maria first of all to give us a presentation, then Philip, and then Gil in this order. I think Maria is there.
Yeah, hello everyone. I'm very sorry for the sound outside. It's some, you know, it always happens when you need a silence. You have a construction work outside. Let me share my slide deck, which I prepared just for convenience of everyone. So regarding data protection laws in Russia, we have a special regulation, of course, which is historically based on the Convention of the Council of Europe. It's an old European convention from 1981. But it's a very important act for Russia because it's a legal basis for cross-border transfers outside of Russia to the countries that are members of this convention. That's the one thing which is very important. And another thing is that this convention sets out the principles of data processing in general. And based on this convention, the law on personal data was adopted in 2006. So talking about the regulation, it consists first of all on the federal legislation, and first of all the law on personal data that I mentioned. We also have information laws, which mainly consists of the federal law on information technologies. And then special regulation like the laws on advertising, labor code has specific provisions on processing of employees' data and other special regulations like the law on communication and the sanctions laws like the code of administrative offenses, criminal code, and so on. Then there is a secondary level of legislation in this sphere, and it deals mainly with the cybersecurity requirements to the protection of information. We have special regulation, a new legislation regarding critical information infrastructure, and some other like industry relating regulation for banks, financial institutions, and others. So that's how mainly the regulation looks like. Talking about the principles, it's very much based on European tradition and on the directive that you, Alessandro, mentioned. So we have very similar principles as mentioned now in GDPR and previously in the directive. I think that this is all for such a quick overview of what we have. And yeah.
Okay, thank you, Maria. I pass the word to Philip if you want to introduce something about your legislation.
Thank you, Alessandro, and good morning, evening, or afternoon to everyone. It's nearly 2 o'clock in the morning here, and we're just starting the second shift, as they say. Well, folks, Australia's privacy laws are very different from Europe, very different from the GDPR, and we would say much more practical and pragmatic. So Australia, which is a continent, by the way, notwithstanding the comments of David Merchant, it is very much a continent, unlike New Zealand. Australia has one privacy law that applies federally. So notwithstanding the fact that we have states and territories, there's one privacy law that operates right around Australia. It is, as I said, very different from the GDPR. We only have 13 what's known as 13 Australian privacy principles. So unlike the 99 articles, Alessandro, that is in the GDPR, we have 13 privacy principles that talk about how to collect, handle, store, and deal with personal information. Personal information is, the definitions are pretty similar around the world, and our definition of personal information is very similar to personal data in Europe. But one of the major differences between Australia's privacy laws and the GDPR, for example, is that we're a heavily notice-based regime as opposed to a consent-based regime. So in Australia, provided that the appropriate notice is given to individuals at or as soon as possible after you collect their personal information, and you tell the individual the purpose for which you're using the information, that is sufficient. The notion of consent is not required. Consent is not required in Australia, except when you're dealing with sensitive information like health information and things like that. But in terms of general personal information, if I can use that expression, all that's required to be given here is notice of the purpose for which the information is going to be used. Now, the other thing that I want to say is that Australia is not recognised as being adequate by the Europeans. Unlike New Zealand, and we still can't get our head around, David and Alessandro, why New Zealand is deemed to be adequate and we're not, because the laws actually are reasonably similar. So there may be some other things at play there, but we're not deemed to be adequate by the Europeans. And in large part because of two...
Can I interrupt for 1 second? You know, there can't be a webinar where there's not Australia, New Zealand envy going on. Okay, that's it.
Thank you, David.
It will be the next topic. It will be the next topic.
But Australia has the reason, in large part, why Australia's privacy laws are deemed not to be adequate by the Europeans is because of two major exemptions that we've got, which I just want to put to you because I think they're very interesting sort of practical exemptions that we have. First of all, our privacy laws do not apply to small businesses doing business in Australia. So, and a small business is defined as one that has a turnover of less than $3 million per annum. So if you're a small pharmacy or a retailer of some description or something like that, and you've got a turnover of less than 3 million per annum, you're not bound by the Australian Privacy Act, the small business exemption. The second exemption that we have is known as the employee record exemption. That means that an employer can deal with its employee personal information in any way it wants, provided it's only for the employment relationship. So, for example, if an employer in Australia wants to transfer employee information offshore for payroll processing, can do. No consent required, no notice required. The employer can do it and transfer it across to overseas, as an example, without consent, provided it's for the purposes of the employment relationship. So there are a couple of exemptions why we think that certainly the Europeans consider us to be inadequate, as it were, even though we would regard them as fairly practical and pragmatic type exemptions. Some other changes that are different between us and Europe, because it's a good way of contrasting our laws, I think. We do not have a distinction between data controllers and data processors. That doesn't apply here. We don't have the equivalent of a legitimate interest exception that Europe has in Article 6. It's all about whether or not, it's all about the purpose for which you notify individuals and using it for that purpose or a related secondary purpose. We don't have the right of erasure, our mandatory data breach notification requirements are not as strict as Europe. So if there's a data breach, you've got to notify here in Australia as soon as practicable, as opposed to within 72 hours. We don't have that strict time limit that we see in Europe. So people say, well then, okay, so you've got your privacy laws. What does that mean in terms of general compliance? And what we say is, because we're not at the same level at the moment, things will be changing, but because at the moment we're not at the same level as the GDPR, if you are GDPR compliant, then you'll largely be compliant with Australia's privacy laws. Not completely, there are some nuances, but generally speaking, if you're GDPR compliant, you'll be compliant with Australia's privacy laws.
Great. From what I understand, a lot of Italian entrepreneurs would like to move there because you told us that you don't need consent, which is a very headache for many controllers here, because they tend to use a legitimate interest instead of consent.
Yeah.
I'm not surprised that you don't have the legal basis of legitimate interest, because very often you don't use the consent as a legal basis. So it's very useful to understand that. And also the fact that the small business are not affected by the legislation is absolutely a thing that many interpreters here would like very much.
Yeah, well, the government's view about that when they were making the changes to the Privacy Act some years ago is that they didn't want small businesses to be hamstrung by all the red tape and the procedure associated with privacy compliance, and they didn't want to burden small business with that. But I expect that it'll probably change in the next few years, though, Alessandro.
Okay. So, Gil, can you give us an overview of what happened in China, please?
Sure. Well, China, the current privacy law is pretty much based on the cybersecurity law, which was passed in 2016 and came into force in 2017, and have a lot of substantive rules on data protections, and has been enforced and since then. So I think that's the current regime. So, but I want to focus more on the current legislation process on the imminent personal information protection law in China. So as you might be aware, China released the first draft of the personal information protection law, which is PIPL, last year. I think we saw a lot of a resemblance to the rules in the GDPR, and just at the end of the April, and the first draft has gone through second reading. So normally one important legislations like this, like personal information protection law or data security law, and that needs to pass at least three rounds of reading before it gets finalized. So now we are really quite close to having a final versions of personal information protection law. So now we have the second draft. So I want to give you more overview of what's likely to come in this very important legislation. So in China, we have existing law with cybersecurity. So all of the data protection principles that you have seen in GDPR and many other countries, data protection legislations are all in Chinese data protection law. Both in the existing laws and also the PIPL, either the first draft of the legislation and second draft. So they're all in there. So it's pretty much the same, and there is an accountability principle there that controller needs to be responsible and documenting the steps to compliance, and then also need to demonstrate how to get to compliance. And there are a lot of rules like transparency, lawful basis, sensitive personal data, and the rights to manage your personal data, right to participations and cross-border data transfer, appointment of DPO, safeguards, documentation, DPIA, privacy by design, etc. You can see all of these elements are also in the imminent PIPL. But I think the significant differences is between GDPR and China is that I think GDPR has many lawful bases where you can choose one that you apply to your processing and for the entire life cycle. But the nuances in China's data protection legislation is that I think the current draft is not very consistent in terms of how they impose the consent requirement. It seems to be there's certain important life cycle of a processing where the consent was particularly emphasized, despite that you might choose different lawful bases. I think that's something that the legislature needs to deal with at the later stage, and they have done so in the second draft. But I think we still see certain things that needs to be fixed. There are a lot of things that need to be clarified by the regulators, and also there are a lot of new requirements such as cross-border transfer. There are restrictions and there are a few mechanisms where you can choose. One is the certification program. I think the idea is similar to BCR under GDPR. And there will be a China version of SEC that will be a prescribed template of SEC that's going to be required by the regulators. The company needs to use that as a mechanism to transfer the data. But the most important one will be if a company has been designated as a critical information infrastructure operator, or if you are big enough, like Tencent or those like mega platform operator that process a lot of personal data, and these two types of companies that need to localize the data in China. And after the first hurdle of localization, then if they need to transfer data outside of China, they need to go through something called security assessment. Security assessment essentially is a government approval that you have to get certain authorities approval before you can transfer the data. So it's quite onerous, but I think under the existing requirements in Chinese law, there are a lot of data localizations requirement, which I'm going to discuss later. But I think this is the overview of what's coming for the China's PIPL, and last but not least, and the imminent legislations PIPL has have defined as well, so it's more so compared with GDPR. So if a company violates the PIPL, and the fine will be up to 50 million RMB or 5% of this revenue in the preceding year. So compared to 4%, I think China is slightly 1% more. And there's also individual liabilities for those, like a responsible personnel and legal representative of a company, and there will be fine and other penalties. And there is a significant lower bar for privacy litigations compared to the existing legislation. So I will stop here, and we will discuss the rest about the PIPL later on.
Okay, thank you, Gil. Coming back to the beginning of this presentation, I mentioned that the real problem, especially for international entrepreneurs or business operators, is the overlapping of legislation. So let's guess, for example, an European or an American entity which wish to do business in your country because, for example, they want to offer goods or provide services through a website, or they want to establish a subsidiary there to provide services, or let's imagine a big retailer which opens shops in your countries. What do they have to worry about? Of course, they have subject to their whole legislation, the GDPR, for example, from the European perspective, but probably they have also to take care of your legislation because they have an establishment there, or they offer services there. So basically, what is the territorial scope of your legislation, and how do you advise the client on this? Phil, Maria, Gil, or Gil, Maria, and Phil. Let's change the order. Gil. Can we switch on the, thanks.
Apologies, so I was on mute. Well, a cross-border data transfer, I think it's certainly it's a difficult, quite complex issues in China. I think there are a lot of sectorial rules in China that already talked about data localizations or restrictions, or even they're like very close to prohibitions of being transferred outside of China. So, so I think, you know, most of the time it's a more of a risk-based approach. Then you cannot really get entirely clear answer on you know, certain areas of the law. We have, you know, this is why let me explain, then you can understand why this is very complex in China. So data privacy is not one ministry's business. You know, we have many authorities that regulate personal data protections and privacy, not so privacy, but I think more data protection in broader sense. So sectoral regulators put in like financial services or medical healthcare sector. They have take healthcare sector as example. We have like a China Drug Administration that deals clinical trials, etc. We have like national health commissions that deals with, you know, medical institutions. That's where many data will be generated, like, you know, medical records, etc. We also have ministries of science and technologies that regulates the human samples and, you know, the human genetic data. So if you look at this, like, you know, that falls in, you know, if you've taken one clinical trials and all of the patient's data that is treated by the healthcare personnel, and there will be medical records and the samples that the data derived from them will human genetic data, and also if you look at this from medical information institution perspective, there will be you know, human population health information. But if you look at from personal data protection perspective, and that will be personal health data, which applies totally different rules. And what's going to add on to that complexity is that the certain regulators, like for example, Cyberspace Administration of China, is trying to add one more concept, which is important data, to the regulate to how, you know, how they want to regulate this set of data. So if you look at one each data, you know, that needs to be transferred outside of China, you need to consider all of these buckets, and each of these buckets may not give you a very clear answer, since oftentimes you need to have more of a risk-based approach. Consider the level, you know, how the law enforcement will interpret certain scenarios, how you want to transfer data with. That's a focus of the law enforcement at the moment. So I think a lot of things, these things need to be considered in order to the questions to answer to a cross-border data transfer. So we really hope that, you know, with imminent personal information protections law and the data security law, I think a lot of these sectorial regulations can be reconciled, you know, again, you know, just by the existence of the new law. So I will stop here, and certainly this is not an easy questions, and feel free to ask questions in the end if you have any particular data transfer issues related to China.
Okay.
Alessandro, I might just jump in before handing over to Maria, if I could, just on the question about whether a European company or an American company, for example, looking to do business in Australia would be bound by Australia's privacy laws. That's a question that's in a sense really easily answered for us. There's the moment a foreign company carries on business in Australia and collects personal information from people in Australia, they are bound by Australia's Privacy Act. If you're carrying on business in Australia and you collect personal information from people in Australia, you're bound by Australia's Privacy Act. There's no requirement to have a physical presence in Australia. There's no requirement to formally register with anyone in Australia. you're automatically bound as a foreign company. And there's a very large piece of litigation going on at the moment where the Australian Federal Court is testing whether a certain social media company is actually carrying on business in Australia because of the way it operates. But merely because though an Australian person can access a website overseas and even order goods from that website doesn't mean that the website operator is carrying on business. You actually have to be offering goods or services and marketing to Australia.
You anticipated my question, whether the mere access to the website from Australia is considered as doing business in your country.
No. You have to have repeat activity in Australia. There has to be a concerted amount of activity in Australia. The mere access from Australia to a foreign website is not considered to be carrying on business.
Great. Thank you, Philip. Very clear. Maria?
From the Russian law perspective, I would follow Philip's comment actually. So rather simple. If you conduct an activity in Russia, then very likely that you will be subject to the Russian data protection laws. Another question is how such laws will be enforced against you if you have no legal presence. But it's then like practical enforcement question. Generally speaking, just the fact that you have an activity in Russia, it creates this condition of application of the Russian laws. Although the Russian laws have territorial scope of application, so they apply to the activity that is conducted in the territory. We have also target tests, so it applies to the data localization requirements that we will talk maybe a little bit later.
That's an issue that is very interesting. I would like to ask all of you
if
you have any kind of data localization duty, because Russia poses a lot of issues for European operators as a consequence of the regulation on data localization. Can you tell us something about that, Maria?
Yes, sure. We have this disputable, very disputable regulation in Russia from 2015, and it requires companies that collect data of Russian nationals to store the data inside the country. Well, simply speaking, this regulation was adopted in 2014 as a part of political crisis, and of course it's very much criticized by businesses because it's not convenient, it's not, well, it's not something good for business. But one of the motives why this requirement was needed is the enforcement against such companies as Facebook and others, IT giants who collect a lot of data but have no presence in Russia.
Can I ask one specific thing?
Yeah,
Can
sure.
you explain us what is the primary database, the second is an issue about that?
Yeah, this is something that goes from the data localization, because the data localization itself does not restrict cross-border transfers. We had rules on cross-border transfers similar to the old European rules, implying adequacy tests and so on. So this regulation was not impacted by the data localization requirement. And this created this concept of primary database, which is like the master file should be kept in Russia, and then you can copy part of this file or the whole file and transfer outside of Russia to store in a so-called secondary database.
Okay. So that means that you can transfer outside Russia the data, provided we are the primary database was established there.
Yes.
Okay. Phil, do you have any kind of, I don't think, from what I understand about the Australian legislation, it doesn't seem that you are too strict and you don't impose too many obligations, but it's up to you. Do you have
That's right, Alessandro. The short answer to your question as to whether there's any data localization requirements in Australia in respect of personal information, the answer is no. So it can be transferred overseas. That's not to say that there aren't laws relating to how you transfer, but we don't have any data localization requirements, so it makes life easier. There are some industry-based data localization requirements. So, for example, there's certain health information that needs to be kept here, but generally speaking, no data localization requirements.
But you were telling me that there could be some amendments or new legislation in your privacy law which could bring some let's say news about the transfer of personal data outside Australia or something like that. What is that?
There may be some changes to the laws in Australia which haven't been introduced yet, but the government's considering strengthening the requirements to obtain consent. Do you know how we are a notice-based regime? They're looking at increasing the requirement, excuse me, to obtain consent before it's transferred overseas. But that's not the same as mandating data localization requirements. That's not on the agenda.
Okay, great. Gil, do you have anything to say about the issue of the data localization? I understand that you mentioned something in your presentation of the general overview of the Russian legislation. Do you have any?
Yeah. Well, I think data localization is certainly the trend for China. I think many regulators, aside from the existing legislations, they're already thinking of making clear a more data localization requirement for different sector, because there's already a general localizations under cybersecurity law. And it's just that how it applies is whether you fall into the bucket of critical information infrastructures. And now it seems like it might be the trends in every sector, despite even though they don't have existing requirements, they are thinking of making such requirements just to make sure that certain companies within the sectors need to localize the data. I think what's not very clear in the imminent PIPL is that while there's an extraterritorial applications that's clearly in the draft of PIPL, and it's not clear whether that will impose will include the targeting factors. But if that if you do any offers goods or services outside of China, but you're targeting, let's put the targeting in the context first. And if you're targeting China's but you put your server outside of China, and then you really collect a large amount of personal data, and there are some provisions that the data localization requirements and cross-border transfer restrictions will automatically fall with you come into play if you are caught by the Chinese data protection law. So that's something not very clear at the moment. If you are caught extraterritorially by Chinese PIPL, whether you will still be subject to these data localization requirement, transfer restrictions, even though initially the data will not be in China, so you are taking a chance that you might not be caught. But what about the onward transfer going forward? So this is a few things that kind of like intertwine with the extraterritorial applications as well as the cross-border data transfer restrictions.
Okay, thank you, Gil. We have just 5 minutes. I would like to ask a question that has been asked by Nicole Feld. Actually, is a question that is a little tricky. The question is, if company complies with GDPR, what are the main gaps to comply with Australia, China, and Russia law? Maybe you need another half an hour, but let's say try to be as exhaustive as possible. So let's assume a company are totally compliant with GDPR who was doing business in your country. What they have to do to be compliant also with your country legislation?
I can jump in if you like, Alessandro. That's a really good question, Nicole. And what I advise clients is essentially, if you're GDPR compliant, there are two things that I'd want to look at to ensure that you're complying with Australian law, because generally speaking, if you're GDPR compliant, you'll be compliant with Australian law. But there are these two things are, we want to take a look at the client's privacy policy, because Australian privacy law says you have to include certain things in your privacy policy that the GDPR doesn't mandate. So for example, in Australia, you have to let people know in your privacy policy which countries you ordinarily send your personal information to. And you actually have to list the countries in the privacy policy and the privacy notice. So it's not enough to say, I will send your personal information offshore to somewhere in Europe. You actually have to specify the countries as much as practicable. I think they're the words. So some changes to the privacy policy. And the second thing is we'd like to have a look at your data, you know, the data transfer agreement or DPA, data processing agreement that the GDPR mandates. We usually like to check that to ensure that it complies with Australia's requirement to take reasonable steps to comply with Australia's privacy laws. So it's really just checking the DPA to make sure it's satisfactory, and usually it is. It gets the tick, but we like to check it. They're the two key things: the privacy policy and the DPA.
Thanks, Bill. Very clear. Maria?
If I could jump in here, I surprisingly I follow Philip's comments already the second time. So the same for the privacy policy. Usually there are some specific wording that is needed from the Russian law perspective, and the list of countries is one of them. Another specifics is that the legal basis for processing is very much different from the GDPR perspective. So if in GDPR we mainly rely on the legitimate interest where possible, it's unfortunately not the case for Russia. And for Russia, it's still the consent that is the most popular legal basis. Unfortunately, it's also not very convenient for businesses, but in many cases, the consent is the safest ground to process data. And this creates a lot of differences, of course, from the practical perspective. But in data processing agreement, the same, we need to check the provisions of the data processing agreement. There are also gaps with regard to data breaches. Simply speaking, there is no, for now, as a general rule, there is no obligation to notify the data protection authority, but there is an obligation to register as a data operator. So it's our legislation in some context is a little bit outdated because it's based mainly on the directive of the EU. That's, well, very briefly, the main gaps.
Thank you, Maria. Very interesting. Gil?
I think, you know, I've already mentioned a lot of like differences between GDPR and Chinese data protection law. So I would say the first thing is, if you are in a very highly regulated sector, I think the automatic thought is just to localize the server. That's something that you might consider doing, and it takes a lot of discussions internally with your security team or infosec team, and it's a lot of investment as well. But I think ultimately, once the law is very clear, and once you face a lot of uncertainty in terms of law enforcement and the data requests, and you might ultimately consider that. I think secondly, it will be the transparency requirements, like the privacy policies, as Phil and Maria mentioned. Well, I think China, going through a few years of law enforcement, the regulators actually have higher requirements on the disclosure in the privacy policies, and we actually need to list out all of the SDK providers in the app, which is not very common practice in other countries. And lawful basis, of course, that's very different from GDPR as well. Legitimate interest, you need to identify those and need to consider swap it with your consent, which kind of completely change if you are doing online services, and that probably will change your entire setup and design. I think last but not least, I think Well, if you are very highly regulated sectors, I would say that map out the life cycles of your processing, but I think there are certain particular life cycles or stage of processing that will be regulated specifically, like, you know, the retentions, like, you know, if you want to utilize certain like anonymized data, and the standard might not be consistent. So I think you know, it takes some time to get prepared for the Chinese data protections law, and being compliant with GDPR doesn't mean that you comply with PIPL, and honestly, Chinese regulator don't care about if a company comply with GDPR. If you take that to talk to the Chinese regulator, and then they don't really care. So they just need to take some time to get yourself ready for that.
So bad news from Jill and from China from this point of view. Anyway.
Sorry, not on a positive note.
Okay, I think we are just in time, very in time. So Maria, Gil, Philip, thank you very much for your presentation. Very clear. You gave us a very clear overview of what happens in your countries. We understand that the overlapping is unavoidable, unfortunately. So the entities which are GDPR compliant, they need to take care also of your legislation. There's no chance to avoid that. It was absolutely clear, but good to know. So we need to advise also in your countries, which is absolutely very safe to do. So I think we have run out of time for today. Is the event is over. We are going to duplicate the event tomorrow for those participants who would like to raise some question or join us. We will be happy to have you with us. And thank you, everybody. Thank you to all the speakers, also the panel one. Thank you, David. And see you tomorrow. See you tomorrow at 4 p.m. Melbourne time. So feel you can be relaxed. Thank you very much. Thank you, everybody. Thanks to all participants of this webinar. Thank you. Bye-bye.
Thanks, Alessandro. Thanks, everyone.
Thank you.
Thanks.
All the best.
Bye.
Thanks, David.